নমস্কাৰ প্ৰিয় দৰ্শক, আমাৰ সৈতে সংযুক্ত হৈ আছে বিশিষ্ট সমাজকৰ্মী সুভাষ চাকমা আৰু খবৰটো হৈছে ইতিমধ্যে আপোনালোক অৱগত যি মন্ত্ৰী গোট অসম চৰকাৰৰ মন্ত্ৰী গোটে প্ৰতিবেদন প্ৰস্তুত কৰিছিল অসমৰ 6 জনগোষ্ঠীক জনজাতিকৰণৰ উদ্দেশ্যৰে জনজাতিকৰণৰ কিছুমান পৰামৰ্শ আগবঢ়াবলৈ সেই মন্ত্ৰী গোটৰ কমিটিৰ প্ৰতিবেদনখন সুভাষ চাকমাৰ নেতৃত্বত CCTOAই গঠন কৰা যিখন কনসালটেটিভ কমিটি এই কমিটিখনে ৰিজেক্ট কৰিছে। তেওঁলোকে প্ৰত্যাখ্যান কৰিছে অসম চৰকাৰৰ সেই মন্ত্ৰী গোটৰ 6 জনগোষ্ঠীক জনজাতিৰ মৰ্যাদা প্ৰদান কৰাৰ সেই প্ৰতিবেদনক নস্যাৎ কৰিছে, অসাংবিধানিক বুলি কৈছে। এতিয়া আমাৰ সৈতে আমি কথা পাতিম সুভাষ চাকমাৰ সৈতে। প্ৰিয় দৰ্শক, আমি ইংৰাজীত বা হিন্দীত কথা বতৰা আগবঢ়াই লৈ যাম। ইন্ট্ৰডাকশ্যনত মই ইতিমধ্যে কথাখিনি ক'লোৱেই। মই যদি সুভাষ চাকমাৰ সৈতে সংযুক্ত হওঁ, চাকমাজি, welcome. As I said in the introduction in Assamese, that the committee constituted by CCTOA, CCTOAI is Coordination Committee of Tribal Organizations of Assam. You had headed that committee. Your consultative committee had rejected the reports of the group of ministers, which gave certain ways to give ST status to 6 communities of Assam, but then you have rejected that report on various grounds. There is a sense prevailing in some section of Assamese, some section of the people of Assam, that you have, or the CCTOA's consultative committee have crushed the aspiration of at least 1 crore people. They say they wanted protection by virtue of some provisions of the constitution to safeguard their identity. So what do you have to say about it? I'll go threadbare why Koch Rajbangsis you think should not be given ST, why Moran or Motok or Chutia or for that matter Ahom should not be given ST. But what do you say about the aspiration of 1 crore people? They say they do not want the status just because they wanted some seats in college and university. Rather they wanted this constitutional safeguard to protect the state of Assam from illegal infiltrators. Your say?
No, I think the grant of ST status has actually nothing to do with illegal immigration or, for that matter, any kind of political aspirations. We have to see that the grant of ST status or scheduled caste status or OBC status, these are affirmative actions for people who cannot match with the general community. So when the constitution was drafted, because of the centuries old discrimination under the caste system, which did not accommodate the lower caste people as well as the scheduled tribes who are outside the fold of the Hindu religion, then the debate took place in the Constituent Assembly how to preserve or how to facilitate the upliftment of these people. And this was not something which started with the drafting of the Constitution. It was actually given under the Government of India Act of 1935, when the depressed classes were given special status, and it was the fight which Dr. Ambedkar had led. So when the Constitution was being drafted, so the whole idea of who could be scheduled tribes and who could be scheduled caste came up. And at that point of time, various committees were set up, including Assam. There was a special committee on the fully excluded areas and partially excluded areas of Assam. Then there were other fully excluded areas and partially excluded areas outside Assam, which was headed by Abhi Thakkar, but the Assam one was headed by Gopinath Bordology, who is one of the most prominent leaders of Assam. So when the Constitution was drafted, it was essentially to be for 10 years, but given the fact that, the discrimination could not be addressed in 10 years because it still persists, although it is reducing to a large extent. So I would say that, the reservation as scheduled tribe has nothing to do with the aspiration to stop the illegal infiltration, illegal immigration, etc.
You do not buy the theory that the granting of ST status will in a way safeguard the identity of these 6 communities. You don't think so? You do not buy the theory, right?
Can you repeat that again? Sorry.
So you do not buy the theory that granting of ST status to these 6 communities will protect their identity. You do not buy the theory. This is because this you.
No, I think, as I say, the identification of the ST and SC are clearly defined in the Constitution.
You're right,
One,
right.
if you are a scheduled caste, then of course you fall within the framework of the Hindu caste system. And
Okay.
If you are a scheduled tribe, then you have to have these 5 characteristics: backwardness, isolation, finance with the main community, etc. So now, if these communities possess these characteristics, then of course they will qualify as the.
They will qualify. Wait, yes,
But
yes.
if they do not qualify, they do
They
not
do not
possess the
become ST.
characteristics, then they do not become ST.
They do not become ST. But if I go community wise, you have given reference of that Bordoloi subcommittee in almost all the in case of all these 6 communities. But then the group of ministers report largely said they are in favor of granting 6 ST status to 6 communities without affecting the facilities already given to the existing tribals. For example, if Assam has 12% ST population, after let's say hypothetically, after granting ST status to these 6 communities, if the ST status population of ST status become 20%, increase of 8%, by increasing the facilities by 8%, can't we accommodate these 6 communities in the larger fold of STs?
No, I think it is not the decision of a particular government. It doesn't matter whether it's the BJP government, Congress government, to define who is a ST. So for the identification of the ST, what is essential, the process is, first of all, there has to be a study by expert to identify whether these 5 characteristics are possessed by these communities. And once they come up with the report, then in that case, the group of ministers or the cabinet will examine it at the state level. Then they will send it to the Registrar General of India, Ministry of Home Affairs. Then the Registrar General of India will forward it to the Tribal Affairs Ministry. Tribal Affairs Ministry forwards it to the National Commission for Scheduled Tribes. National Commission for Scheduled Tribes examines it. So it is not an executive decision in that sense, who should be ST or who should not be ST. And if you look at the cases, for example, the Gujars in Rajasthan, or the Jats who were given status as OBCs by the government, which was actually declared unconstitutional by bench headed by Ranjan Gogoi, Chief Justice Ranjan Gogoi himself. So the process of identification is not a political decision. It has to be a decision by the experts. So in this case, the whole point was, first of all, there was a committee of the Bordoloi committee, which you cannot actually go beyond the committee because it was part of the Constituent Assembly debate when the Constitution was being drafted. Then there was, once again, the issue was re-examined in 1965 by the local committee. Now the government of Assam itself then conducted another study, and they have found that these are scheduled, they follow the caste system, so they define them as other backward caste. So OBCs. So for even notifying them OBCs, the government of Assam had to conduct a study. After a study, then they had to submit the reports to the National Commission for Backward Caste. And once National Commission for Backward Caste has earlier adopted or decided that these are the OBCs, you cannot change the, the characteristics of the communities just because there is a political expediency. So in a way, it is actually a very, very technical debate, because it has nothing to do with the numbers. The way I think we have to understand, and people who are from both sides of the spectrum, meaning those who are seeking ST status and those who are opposing the ST status, because if the moment the government, changes the groups from one category to other category, it becomes, then the sanctity is not there. If the sanctity is not there, then it becomes very, very difficult for anybody to accept it.
The group of ministers instituted by government of Assam wanted, or they are the group of ministers is in favor of creating a separate category, ST Valley. There will be ST Hills, there will be ST Plains. In fact, in Assam, there is ST Hills and ST Plains. They wanted to create a separate category of ST Valleys, Scheduled Tribe Valleys, and incorporate certain groups, certain communities of these 6 communities in that group. So that is also unconstitutional, or there is no provision as such to categorize one certain community as ST Valley.
No, you can categorize as ST Valley or any number of categories you can create, so long they fulfill the criteria to be the scheduled tribes. And I think that's where the difficulty was. First of all, that whether they fulfill the criteria to be scheduled tribes. I mean, now there was a committee by Gopinath Bordoloi, which was part of the Constituent Assembly, local committee. Then you have the National Commission for Backward Caste. These studies were conducted by the Assam Institute for Research for Scheduled Tribes and Scheduled Caste. Now, I mean, you in a particular state, one particular group cannot be, classified into different categories. So you can classify as many categories within the ST as you want, but it is subject to the, fulfillment of the condition that they shall be considered as the STs. Now, there were earlier committees which considered that they are not STs. So you had to come out with certain facts to negate those reports. And it is not something for the group of ministers to decide, because this is to be decided by the experts. And in this particular case, what has happened is the government of Assam has not even gone back to its own Assam state, Assam Institute for Tribal Research. They hired somebody else, because for identification, your own findings from the previous Assam Institute for Research on Tribals and Scheduled Castes, they already classified them as, SCs or as OBCs. You can reinvent by inviting new experts. So that's where I think
the bottom line is, you said very technical, these 6 communities per se do not fulfill the 6 or 7, 5 or 6 criteria of local committee. So they cannot be ST. This is not a political decision. This is primarily an executive decision where at least 2-3 central agencies are involved, including Anthropological Survey of India, National Commission for ST, Registrar General of India. Then cabinet, then cabinet will get involved. Then there will be a draft, and that draft will be converted into a law in the Parliament of India. Now, if I remember, in 2019, bill was tabled in Rajya Sabha, and the bill was to grant 6 ST status to the 6 communities of Assam. The process of tabling a bill in the Parliament comes when you fulfill all other procedures, approval from National Commission for ST, approval from Anthropological, approval from other agencies. So what do you have to say about that ordinance bill?
See, government can place any bill, and after placing the bill, it can be declared constitutional or unconstitutional by the court. Even at this point of time, if the government so wishes, they can obviously enact the law. And it has happened with the judge in Haryana. The government approves it, president actually assents it quickly, it becomes into a law. But ultimately, it has to stand the scrutiny. A law passed by the parliament has to stand the scrutiny of the the courts. So they may, if they wish, they can do it, but otherwise, it has to stand. I think in this particular case, the government of Assam is very clear. They know the difficulties. One of the recommendations which they made is that the 2 constituencies, parliamentary constituencies, Dipu and Koch Rajbangsi, should be reserved for the existing scheduled tribes. But that is not something which is allowed anywhere in the law, because at the central level, there is no sub-classification of the scheduled tribes. Sub-classification takes place only at the state level. So if you look at the central level, it's 7.5%. So if you say out of the 7.5%, the seats in the parliament, if you say 2 seats are reserved only for the ST Plains and ST Valley of Assam, you are actually opening something, Pandora's box, not allowed by the Constitution. So they know that even though they are recommending it, they are actually not necessarily on the correct legal footing. So that's why the recommendation which they come up from the group of ministers in a way fails to capture the entire issue. And this issue comes up only, if you remember, this issue comes up only during the election times. it's not only BJP. If you look at throughout the period from Tarun Gogoi's time, when the election comes up, the issue actually heats up without people realizing. Without people realizing that this is half-hearted measure. The moment you recommended that two seats in the parliament, Dipu and Koch Rajbangsi will be reserved, the state government itself killed the entire process. How can the government of India make a provision to pass this bill to reserve 2 seats of parliament only for 2 subcategories of scheduled tribes in Assam? Is that feasible? Absolutely not feasible.
So then they speak about delimitations. The number of seats will be increased, and by increasing the number of seats in parliament, or for that matter in assembly, the new groups will be accommodated. That is the theory they come up with. But then now I have certain questions on the report or the press release you have prepared rejecting the GOM's report. So you said categorically and very clearly that these 6 communities do not fulfill those characteristics needed to be incorporated in STs. But then if you see the original list of 1950, if I am not mistaken, there were how many? 300 communities. And right now, if you see the list, it has 700 or so communities. So in the course of last 75 years, maybe 400 new communities were included in the list. And by Article 342, the President of India has the power to include or to remove any community from the list if criteria are being fulfilled. So if in the course of 75 years, new communities were included, so that is an argument which comes up from the leadership of 6 communities. What do you have to say about it?
No, in that particular case, I think many communities which we are included into the scheduled tribe list, they were included after, as I said, research conducted by government experts. So usually it's the tribal research institutions.
Same thing,
So
yeah.
these communities usually are communities whose status was not determined. In this particular case, at least in the case of the Adivasis, the status was already determined both by the Bordoloi committee as well as the local committee. And now in the case of the 6 communities, what had happened was that they were already identified and accepted as other backward classes by another commission, which is the National Commission for Backward Caste.
Right.
So the fact that the backward caste has already identified them as, scheduled, usually as other backward castes, it makes their case to be identified as scheduled tribes very difficult. And in fact, one of the questions, if ever it reaches that stage, would be, which commission do you believe? One commission, which is the National Commission for Backward Caste, based on the studies done by the Assam's Tribal Research and Scheduled Caste Institute, saying these are, scheduled, other backward caste, and another group saying, so that dilemma is also the distinction here, the difference here with respect to the 6 communities. Their status, in a way, has been determined. But the other communities which were included into ST categories after independence, they were basically not included in any one of the groups. So they claim they were STs. So in that sense, their applications were fresh.
Yeah.
The strategy were different. So that's the difference. I think one of the dilemmas which anybody would face is that there is a commission which is again empowered by the constitution, by law, which is National Commission for Backward. So that's why the dilemma is, and that's not something
there is a visible, there will be a visible conflict between National Commission of OBC and National Commission of ST. Okay. Okay. Now I have one point. Another question to you, especially about Ahoms. Ahom were the largest communities, probably after Adivasis, in this group of 6 communities. Now, okay, you said these 6 communities do not fulfill the criteria to become part of ST. Now, in the case of Ahom communities, you mentioned in your press release that they ruled Assam for 600 years, some part of present-day Assam for 600 years. But there would be other communities also who are part of ST. They had their own kingdoms like Khasi communities. I understand you said they do not fulfill these 6 criteria. But among the Ahoms, one certain family ruled certain parts of Assam, modern-day Assam. So how does that reasoning fit into the whole concept of not granting them ST?
No, I think, I mean, it was not so much about they have ruled the 600 years, which was stated by we basically quoted the report of the group of ministers. What our whole contention was that, I mean, the rejection for that was that, I mean, because they were identified as part of the Hindu religious system, and because they were already classified as OBCs, so they would fall into the caste system. So that was the only reasoning, not so much about because they have ruled for 600 years. Whether they rule for 600 years or 200 years, that's not an issue. If you look at, say, for example, Tripura Maharaja or Tripuri.
Khasi is also.
Yeah, so that's also a case, but they are scheduled tribes. It's not it. So I think the whole issue was at least in the case of Assam, I mean, it was more about the determination by the National Commission for Backward Classes that these are the Tribal Research Institute, that they are actually part of the Hindu religious system and they should be classified as OBCs. So that's what I think our position was, not so much about how many years they have ruled.
Yes, as I understand, you're saying like SCs, the people who are included in SCs, they are very much part of Hindu fold and they face discrimination for thousands of years. So they were given the SC status. So by virtue of their the benefits they get from being SC, they come to the mainstream. Likewise, OBCs also you're putting them in the larger Hindu fold, right?
Yes.
OBCs,
right? Yes.
So
because the National Commission for Backward Castes.
National Commission for Backward Caste. When I say caste, when we say caste, so it is the larger Hindu fold.
Yes.
I got your point. Yeah. Now, again, in the case of Koch Rajbangsis, which is also one of the largest tribe by virtue of population, you say the group of ministers combine 2 communities into one. Koch, they are different communities, Rajbangsis different communities, and Koch in West Bengal, they enjoy SC status. If they enjoy SC status in West Bengal, how can they get ST status in Assam? What is your deliberation on this?
No, I think that is only what to say. One of the critical points is that I think it is the contention of all other members in the consultative group saying that Koch Rajbangsi are 2 different groups. And with respect to the Koch, I mean, basically, they were recognized as a scheduled caste in 1950 itself in West Bengal. Then, of course, in Assam, they were recognized as an OBC. So there is some similarity, or at least common findings between by the state of Assam as well as state of West Bengal prior to that they belong to the caste system. So if you belong to the caste system, then your reservation would be for or as per the reservation for the caste system. So that was the more specific point that 1950, because if it was found in 1950 in West Bengal that they were actually scheduled tribes, not scheduled caste, then obviously, I mean, other commission would have led, found similar conclusions. So I think because 2 state institutions found the same conclusion that they belong to the caste hierarchy or caste system. So that was the reason why it was rejected.
You mentioned it, but is not that same thing apply to the Adivasis? Because certain communities in the Adivasis or the T tribe, we call them, they enjoy ST status in their original state. But in the report, you say they migrated for some reasons during British rule, and and when they came to Assam, started living in Assam for many years, they lost their original characteristic of being ST, which was there in their original state. If this Koch theory is applies to those people living in Assam and West Bengal, the same theory doesn't apply to the Adivasis. ST in
Well,
original state?
see, in the case of the Adivasis, I think it is not our finding. It is the finding of the local committee, where they specifically mentioned that they no longer possess the characteristics which would define them as tribals. So if you look at the entire report, it's not so much of our own findings. We basically, amalgamated the findings of the earlier, commissions and committees, because we are not the competent authorities in a way to identify who is a ST or who is not ST. So our purpose was to basically collate the entire studies which have been done on these communities. I think with respect to the Adivasis, if you look at the reports of the expert committee, which was set up by the current government of Assam, the group of ministers, based on which they were saying they should be scheduled tribes. So even the current government's report, the expert committee said 36 out of 74 the Adivasi communities, they should be listed as scheduled caste, not as scheduled tribes. So the findings of the earlier committees was absolutely true, which has already been found today. And I think where the Assam government made the mistake, knowingly or unknowingly, that once your own expert committee says somebody is a scheduled caste or somebody is a scheduled tribe, it is not for the executive, it is not for a minister, it is not for a secretary to redefine them, to reclassify them, because that's a task of the expert committee. So I would say I think it is based on the previous findings and current findings of the expert committees that the Adivasis also have become scheduled caste.
Okay, so I think I have covered all the points now. You have given the reference of Lukur committee. That was this is my last question. I think you have given the reference of Lukur committee that was from the 1965. That committee came up with certain characteristics, 5-6 characteristics. But then I read while I was preparing for this interview that there was a task force instituted in 2014, and this task force recommended for certain newer characteristics to define a community for incorporation in ST list, because time had changed. Certain criteria fixed by local committee were outdated and obsolete. Do you think, general question out of this 6 community fold, do you think time has come time has come to find out new characteristic to incorporate communities in the ST list? Also, time has come for certain communities to be removed from the ST list, and also time has come for, as Supreme Court said, there should be a subcategorization among STs, because this is not a ST list. Last communities in ST list are not homogeneous. In the list also there are certain communities who are advanced. There are certain communities who are backward, even if they're incorporated in ST list. Time has come for subcategorization.
Subcategorization is already allowed. Recently, in August 2024, there was a judgment which was given by the Supreme Court of India. It was a 5-bench constitutional bench, State of Punjab versus Devinder Singh. It was delivered by then Chief Justice Chandrachud, basically saying in order to bring certain backward tribal groups or certain backward scheduled caste groups within the broad scheduled caste, scheduled tribes which exist now, the state can subclassify them for upliftment. So I think, what the critical issue here is that, when a state examines, of course, it basically means there is a call for review of all these decisions. Now, the issue would still be, one of the criteria would be, say, for example, the economic backwardness, educational backwardness. So all the yardsticks which define backwardness. So in each state, obviously, there is scope for, the reclassification, subclassification, re-identification. What would usually happen is that in the reservation system, reservation also for all practical purposes, frankly speaking, has become a political issue. It is as much as the need for social upliftment, which is absolutely needed because of the system, the societal, the society we have come from, or the Indian society is all about. So there's a need definitely for it. But at the same time, I would say that this is also a political issue. For example, prior to 1987, the Minas of Rajasthan, we are not classified as a scheduled tribe status. Then they were included in 1987. Whether they are scheduled tribes or scheduled caste, it has never been heard. The constitutional validity application never been heard. But it is also a fact that Minas who possibly constitute less than 2% of the population. I have done a study in 2018 that in the UPSC examination, between 40 to 42% of the seats in all the UPSCs are taken by the Minas. So obviously, this is a system which is not perfect. It needs review. It needs sub-classifications at times. And I think what the government of Assam and all of us need to remember in the case of Assam, I mean, there are political traits which you had mentioned in the beginning, like the immigration, migration, whatsoever. And in the course of my studies, I found one interesting thing. That interesting thing is, Gwalpara district has been the cradle of migration into Assam.
Yeah.
If you read the NRC judgment, it refers to the census which was done in 1931. But census was started in 1881. All these old census reports on Assam, if you read 1881, 1891, 1901, 1911, and 1921, you'll see when the people were coming from Bengal and coming from Chotnagpur Plateau, etc. They were all used to be taken to Gwalpara. And what surprised me is that, after, going through this entire process of migration of people which Assam had seen, and the Ravas actually bore the brunt. I think, there is also a need for, people in Assam to, while we exercise or demand rights of other people, that some of these smaller communities needs to be protected, because some of the population is only 3 lakhs, 4 lakhs, 5 lakhs. They'll just submerge. But I found it.
I got your point. You're saying Ravas needs to be protected more than Bodos, like if we compare.
No, I won't say that, but I was just thinking,
Yeah, that is a very serious issue. Ravas were the sentinels of the borders. They need protection.
Yeah, Ravas, they had suffered the brunt of migration, not today, from the British Empire.
Right.
That's what I'm saying. First report of 1881, and I was reading them when I was doing research on the NRC issue, etc. But I was just thinking how whether a community could actually survive after going through so many processes of migration from the starting of the tea gardens by the British till the partition, then after the partition, so I'm not comparing with any other community, but it's a bit still, it's a positive thing that they are still surviving.
Yes, right. Kudos to the Ravas. They survive, and they're standing tall even today after facing that much of brunt during British era. Last question that came to my mind. In fact, this was part of my preparation also. You took the reference of, you gave the reference of that 1993, I think, judgment, Indra Sahni judgment. So by virtue of Indra Sahni judgment also, you say these 6 communities of Assam cannot be granted ST status because 49% is allowed. If those are incorporated in Assam, the reservation will exceed 50, 49, 50%. But there are some states in India where reservation exceeds 50%. What do you have to say?
Well, if the constitutional validity of the reservation is challenged, then of course they will be declared unconstitutional. I think what we have to bear in mind is that the reservation is allowed up to, it has to be below 50%. Then in the exceptional cases, 10% is allowed with respect to the economically weaker section. So in that sense, Assam is still in the threshold, but there are 34 communities among the Adivasis who are not listed either as ST or SC. at this point of time. And if they were included, and the percentage will definitely cross, what is permitted by the Supreme Court, even with the exception of the economically weaker section, that there has to be readjustment. And readjustment of reservation would have, it has to be, based on the population, the proportionate to the population. So the risk is that, smaller communities might still suffer. So even if you grant, what we basically caution Assam government is that for political expediency, even if you require it, please remember that, ultimately, whenever you come out with some formula, accommodation here, quantum of reservation, etc., you cannot go against the judgment which has already been set.
The Supreme Court judgment.
Yes.
So I think I covered all the points. This is something which is which has become talking points, and because of the election as well. As you said, this issue becomes prominent when election comes, and the leaderships of 6 communities, although they have been demanding ST status from many decades. So how they react to this committee, we'll get to know about it in times to come, maybe today or tomorrow. Nice talking to you, Subhash Chakma. You gave us this time. প্ৰিয় দৰ্শক, সুভাষ চাকমাৰ সৈতে আমি কথা বতৰা পাতিলো। তেওঁ কিয় প্ৰত্যাখ্যান কৰিছে 6 জনগোষ্ঠীক জনজাতিৰ মৰ্যাদা প্ৰদান কৰাৰ বিষয়টো আমাক পুংখানুপুংখকৈ ক'লে। অনাগত সময়ত কি প্ৰতিক্ৰিয়া আহে 6 জনগোষ্ঠীৰ নেতৃত্বৰ, সেয়া সময়ত গম পোৱা যাব। গতিকে এই চিন্তাৰ সমলৰে মই আমাৰ কথোপকথন সামৰিছো। ধন্যবাদ।
আপুনি বিচৰা বাতৰি পাব কেৱল নিউজ 18 এপত। নিউজ 18 এপ ডাউনলোড কৰিবলৈ স্ক্যান কৰক এই QR কোড। Google Play Store তো পাব এই News18 এপ।